Hello, everyone, and welcome back to the AI in Legal series. I'm Terry Modishead. I'm the Executive Director of the Centre for Legal Innovation at the College of Law, and absolutely delighted to welcome today our very special data guru. I'm going to call you Crystal. Crystal Jackson, who's the eDiscovery Senior Manager at Ashurst Advance. I'm going to hand you over to Crystal in just a second. Today, we are talking all things data, unlocking the power of data. It's a fabulous title and obviously very applicable. I'm going to disappear, Crystal, but we'll be lurking behind the scenes and hand over to you. Welcome, everybody, and welcome, Crystal.
Thanks so much, Terry. Hopefully I can live up to the data guru title. Actually, to do with the title, Unlocking the Power of Data, I actually got that from ChatGPT. So if you ever want to have a nice intro to your presentations, that's a great use for it. Thank you so much for allowing me to speak today on unlocking the power of data. In this fast-paced, ever-changing digital era where information is abundant and technology continues to shape our world, it's essential for us to understand and embrace the power of data in our organisations. In this presentation, we'll delve into topics of data management, e-discovery challenges, data governance, and the potential of AI in the legal field. We'll explore how these concepts interconnect and how they can revolutionise document review, analysis, and decision-making processes. Data, as we know, is the lifeblood of the legal profession. From contracts and court opinions to client communications and internal documents, the vast amount of information requires efficient management and comprehensive understanding. Additionally, the growth of electronic communication and enterprise data resources has brought about unique challenges in the collection, analysis, and review of digital information. To navigate this complex landscape, we'll discuss the importance of data governance in maintaining data integrity, protecting privacy, and complying with legal and regulatory obligations. Data governance provides the foundation of effective data management strategies, ensuring that we can leverage the power of data while safeguarding sensitive information. We'll also explore the role of AI, specifically continuous active learning, or CAL, and sentiment analysis in transforming analysis. We'll also examine the benefits and drawbacks of cloud-based storage, the ethical considerations around AI adoption in the legal field, and the potential implications for legal professionals and the justice system as AI continues to shape our profession. Hopefully, you'll leave this presentation with a comprehensive understanding of the integration of data, e-discovery, data governance, and AI in the legal practice, and excited to explore the possibilities and challenges that lie ahead. Before we start, a bit about me. I've been working in e-discovery long enough to remember having to print out document IDs on labels and manually labelling each page before scanning. I've worked in government, tech startups, law firms where the challenges of data can vary, but ultimately the principles and best practice stay the same. I started my journey record keeping for the Crown Solicitor's Office and am now the Melbourne Senior e-discovery Manager at Ashurst Advance. Ashurst Advance is Ashurst's market-leading full-service new law offering and one of the firm's 6 global divisions. We work seamlessly with Ashurst's legal and consulting teams to deliver innovative and holistic legal and business solutions to our clients. But what is data? Back in the old days, data was anything that you wrote on. With increased access to technology, we're seeing the scope of data change. It's not unusual for a data collection to be a terabyte or larger. So what is it that we're collecting, and why could it be pulled into scope? Emails is usually what you first think of when you think of data. While we shifted from forensic collection to clients collecting their own data using software like Office 365, collecting emails can still be a minefield if the correct systems of data retention and storage have not been put into place. We'll delve into some of these headaches later when we speak of data governance. Documents can be any document saved to your computer, documents you've saved to a document management system, documents on your iPad, and you'd be surprised how many documents we still receive in hard copy, being meeting minutes, notepads used in investigations, or board papers. Anything that's been created, electronic or otherwise, that provides information or evidence on the matter at hand. Surely that covers everything, right? What else could possibly be in scope? Now, this one always sends alarm bells ringing. Everything that you search, open, click, read, download on your work computer or iPad is likely being tracked. We have pieced together timelines with this information when there are clear missing pieces in emails. Let's say I send my mate Phil an email saying, "Have you got a minute? I've just seen something alarming." You might pull up my movements for the day and see that I've opened an email saying that a company is about to go into foreclosure. And I've logged onto my share trading site and sold my shares. Then let my mate Phil know because he's also a shareholder. We'd not be able to find any of this data in documents or emails, but you might have found it if you'd collected phone records. Not only can you track every movement I make on my work computer, you can also see everything I've accessed on my work phone, including call logs and messages. With the invention of apps like Signal or Telegram, it's easy to get in the mindset that what you are texting will be impossible to find. However, once something is created on the internet, there's always a record for it somewhere. It's just harder to locate. Personal devices can also be brought into scope. Let's say I've texted my friend Jackson on a personal phone and advised him to sell his shares, but Jackson's phone is company property. Jackson's messages may implicate me enough to have my personal phone collected. Not to sound like an elder millennial, but it seems the fear of writing things down in chats has disappeared of late, with clients, partners, and e-discovery professionals being mortified that their private chats are in scope and that they will be reviewed by lawyers. I might have been having a bad day and messaged a teammate to blow off some steam about a client, and now that chat is discoverable in court. Teams, Slack, Google Chat, Discord, and any chat program you have posted about work in is potentially in scope. When forensic or e-discovery professionals receive orders or instructions to collect, we'll be asking the location, size, and accessibility of this data and how it's been stored. Understanding the difference between structured, unstructured, and semi-structured data is essential when considering data collections, review, and disclosure. So let's break down each type. Structured data is organized data, highly formatted information that fits neatly into predefined categories or fields. It has a consistent structure, making it easy to search and analyze. Examples of structured data might include databases, spreadsheets, and financial records. You might have had some experience using a document review platform that allowed you to search through data, tag documents for relevance, and run analytics. This is usually the end of some e-discovery magic. However, what we usually receive first is unstructured data. This refers to information that does not have a predefined structure or format. We usually see this with text documents, audio recordings, images, videos, social media posts, and websites. Unstructured data is often created by people and lacks consistent organization, making it more challenging to manage and analyze. I often liken this structure to your downloads folder. You've got everything in your downloads folder, from a great article that you saved, a recording from a meeting you attended, a receipt you needed reimbursing. It's full of useful information, but without renaming and sorting into folders, it's going to take some time to find anything you need. Semi-structured data lies between unstructured and structured data, combining elements of both. It has some organizational structure, but does not conform to strict formats. Semi-structured data is often includes metadata or tags that provide a level of organization or categorization. Semi-structured data allows flexibility in content and format and allows for variations and presentation of data. And with the help of techniques like data parsing, semi-structured data can be partially organized and processed. We see this quite often with self-collections. My company might have its own file sharing system, and rather than handing over all my data to a law firm, I might create folders based on categories of a notice to produce and put relevant documents into their corresponding folders. I'm unlikely to be able to search or tag documents in any helpful way or run any analytics while the documents are in this format. However, I can easily find the documents relevant to each notice and report on the contents of the folder. It's worth noting that the more you move documents around and sort them manually, the higher the risk of altering important metadata such as document dates and titles, which leads to data sources and their implications for legal analysis. You might be thinking, gee, Crystal, this is really interesting information, but I just need to send some documents to court. Why do I need to know about all of this? Understanding the distinctions is crucial for legal professionals, as different types of data may require different distinct approaches in terms of storage, analysis, and compliance. Properly handling unstructured, structured, and semi-structured data is essential for effective e-discovery, data governance, and leveraging AI technologies. So let's go through some common data sources and their implications when conducting legal analysis. Custodian data sources refers to information generated and stored by individuals or entities directly involved in a matter. As we've discussed, this is not just the contents of your inbox. Identifying and collecting data from custodian sources is essential for preserving potentially relevant evidence. Analysing custodian data can help uncover critical information, establish timelines, and people of interest can be uncovered. We have found in the past, analysing something as simple as the timeline of all the emails sent in the custodian inbox can tell us if the data collected is not complete or shows that emails have been intentionally deleted from an inbox and further analysis of a legal hold may be required. But what can happen if the data storage and collection has not gone to plan? You'd be surprised how many clients come to us and say that they changed email servers or chat platforms 2 years ago and they're no longer able to retrieve that data. Or an employee has left the company and their records are no longer available. It's not uncommon for clients to not know where their data is stored, what their data retention policies are, and who has access to any archived data. It's these kind of questions e-discovery would be asking when collecting data, but you should be asking these questions of your company. It's quite embarrassing to have to stand up in court and admit you're not able to find documents because your company didn't have the right procedures in place. Identifying relevant custodian and collecting data can be challenging, especially in complex litigation or investigations involving multiple parties and different data sources. Coordinating IT departments, custodians, and potentially opposing parties to obtain necessary access and cooperation is vital. Now that most IT departments have access to run searches and export data directly from inboxes, clients will often self-collect data to save costs. It's important that if you are doing so, you understand the risk taken. Something as simple as searching across an inbox for a keyword can cause issues if the keyword is inside an email attachment that is not text searchable. It may be that you've looked in your own inbox and saved some relevant emails onto your laptop, downloaded a few documents out of your document management system, then forwarded these emails to your lawyer for review. By collecting documents in this way, you have potentially altered the metadata of the files. This might not be an issue depending on what you're intending to do with the documents. But if you're wanting to upload them to a document review platform with an altered date and title, it can affect searching or deduplication, causing additional costs and time delays that could have been avoided with proper collection. Electronic communication sources covers platforms used in digital communication. While custodian sources focus on the individual, communication sources can be email distribution set up for projects, Teams channels, collaboration tools, and social media platforms. These sources contain conversations, discussions, and exchanges that can be relevant to a legal matter. If stored and collected correctly, electronic communication sources often hold valuable evidence for establishing intent, agreements, and knowledge. Analysis can be done to identify key conversations, relationships, and patterns. I have a great story on pattern identification when we talk about AI later. In the new age of technology, it's getting harder for organisations to control the amount of data being generated, let alone collect it for legal purposes. As new platforms and apps become available, organisations are potentially losing data for the sake of innovation. It may be that a Kanban board has been set up for a project on someone's personal account rather than through company, or where a team has found it easier to communicate through WhatsApp rather than the organisation's recommended chat software. Having data that is not centralized and policies that are not enforced will mean that a lot of electronic communication sources will not be available to collect if needed. When dealing with multinational organizations or cross-border litigation, data collected from electronic communication sources may be subject to different legal jurisdictions and data protection laws. Ensuring compliance with international regulations, addressing data transfer restrictions, and managing conflicts of law become important factors. If data is collected without ensuring compliance, it may not be admissible and can trigger further legal action. Electronic communication sources may have sensitive information, so collecting and handling of this data must be done with the utmost care to maintain confidentiality and comply with relevant data protection regulations. Implementing appropriate data security measures and considering privacy concerns is essential, as privacy breaches can lead to reputational damage and may put the organisation's security at risk. Enterprise data sources consist of data generated and stored within the organisation's internal systems and databases. This includes financial systems, customer relations management databases, enterprise resource planning systems, and other repositories of structured data. Analysing enterprise data sources can provide insights into business operations, transactions, and internal communications. Understanding the structure and relationships within the enterprise data sources aids in identifying relevant data sets and conducting efficient data analysis. Compliance with data governance and data privacy regulations is crucial when handling enterprise data sources. Organisations may have complex or out-of-date data retention policies for internally generated data, or they may be stored in legacy systems and in outdated file formats. Retrieving and accessing this data from these systems can be challenging, especially if the systems are no longer in use or lack proper documentation. Enterprise data sources often contain sensitive and confidential information, and data security and access controls are put into place to protect this information. Obtaining necessary permission, access rights, and ensuring data security while collecting can be a challenge, especially if the accessed information has not been stored correctly or is operated by a third party. Ensuring the quality and integrity of the enterprise data is crucial. Data inconsistencies, inaccuracies, or missing information can impact the analysis and interpretation for the data, especially when analysing databases. It may be that a client has been accused of underpaying staff, so entire financial systems could be analysed to understand how payments were made and identify any underpayment. If the financial data retrieved is incomplete, the analysis of the data would not be correct and could lead to further legal issues. There are many more data sources, such as hard copy, external system logs, voice and call recordings, surveillance systems. However, custodian communication and enterprise data are the three main data sources we see in the legal industry. Understanding the diverse data sources and implications of improper data storage and collection allows you to design comprehensive data retention and collection strategies, employ appropriate preservation techniques, and understand the risks when collecting data without an e-discovery or forensic expertise. So where should we be storing this data? It seems like less of an argument in these post-pandemic world that we live in, but we are still hearing organisations declare that their data will never go into cloud storage because they don't trust it, without understanding that their entire organisation is already using cloud storage in several ways. But while cloud storage offers several benefits, there are also potential drawbacks to consider, so let's explore both sides. Cloud storage allows organisations to scale their data capacity up and down as needed, providing flexibility in managing growth and storage requirements. It eliminates the need for physical infrastructure upgrades and provides on-demand storage resources. Cloud storage enables authorised users to access data from anywhere with an internet connection, facilitating remote work, collaboration, and client interaction. It enhances mobility and enables seamless sharing and collaboration on files and documents among team members. This functionality became vital when organisations had to quickly adapt to working remotely during lockdowns. Cloud storage eliminates the need for large upfront investments in hardware, infrastructure, and maintenance costs. You can leverage a pay-as-you-go model, paying only for the storage resources you need. It reduces the need for dedicated IT resources and infrastructure management. Cloud storage providers often implement robust backup and disaster recovery measures, including data redundancy and protection against data loss. Automatic backups, data replication, and geo-redundancy features provide peace of mind for organisations in terms of data integrity and continuity. Reputable cloud storage providers offer robust security measures and compliance frameworks to protect sensitive data. They invest in encryption, access controls, and adhere to industry standard security certifications and regulations. If you're considering cloud storage but believe the PC in your computer is more secure, you might consider how many integrity checks are being done over the PC or what kind of recovery is in place in the event of outage or failure. Now that I've convinced you all on the superiority of cloud storage, like any good thing, there are risks associated. Depending on the location of the cloud storage provider servers, there may be implications for data sovereignty or jurisdictional requirements. Organisations should consider local regulations and legal requirements regarding data storage and cross-border data transfers. Cloud storage relies on internet connectivity to access and manage data. In areas with limited or unreliable internet access, organisations may face challenges in accessing critical data and maintaining productivity. Backup contingency plans should be made in place for such scenarios. While cloud storage can offer cost savings in the short term, over time, long-term costs may accumulate. As data costs needs grow, costs can increase, and organisations should monitor usage and pricing models to ensure continued cost efficiency. Vendor reliance and service interruptions. Organisations depend on the reliability and availability of their cloud storage provider. Service interruptions, downtime, or vendor-related issues can impact access to data and continuity. Contractual agreements and service level agreements should be carefully reviewed to mitigate risks. Yes, I know I just made a convincing argument for the security of the cloud, and cloud-based storage continues to beat on-premise storage on data durability and availability. There is always a risk of storing your data in the cloud. In many ways, data stored in the cloud is more secure than local servers, but it does not eliminate all potential security risks such as unauthorized access, data breaches, or data loss. It's crucial to carefully evaluate the security practices, encryption protocols, and compliance standards of the chosen cloud storage provider to ensure data protection. When considering cloud-based data storage, organisations must conduct a comprehensive assessment of their specific needs, security requirements, and compliance obligations, and evaluate the reputability and suitability of cloud storage providers, not just for your own organisation, but for any organisation that you might be sending data to. Is their environment ISO certified? Will a third party have access to your data? Will your data leave Australia? A well-informed decision supported by careful planning and proper risk management can maximise the benefits of cloud storage while mitigating potential drawbacks. Where to store data is the first question, but the more important question is how. With a new data breach reported every week, each organisation wants to talk data governance and why do you need it? And while security of data is the most visible issue, data governance encompasses much more. Data governance refers to the overall management and oversight of the organisation's data assets, including the processes, policies, and controls put in place to ensure data quality, integrity, security, and compliance. Here's a breakdown of its key components and their importance. Firstly, data governance establishes standards and procedures to ensure that data is accurate, complete, consistent, and reliable. It involves implementing data validation rules, data cleansing processes, and data integration techniques to maintain data quality. By enforcing data integrity measures, organisations can rely on trustworthy data for legal analysis and decision-making. Secondly, it includes policies and controls to protect sensitive information, such as client data and privileged communications. It ensures compliance with data privacy regulations, establishes access controls, and implements data security measures to safeguard confidential data. Maintaining data privacy and confidentiality is essential for maintaining client trust and compliance with legal and ethical obligations. Additionally, it defines a framework of categorizing data based on its sensitivity, value, and legal requirements. It establishes data classification policies and guidelines, helping organizations identify critical data, apply appropriate security measures, and determine data retention and disposal practices. Effective data classification enables efficient data management and reduces risks associated with data mishandling or unauthorized access. It also ensures compliance with the relevant laws, regulation, and industry-specific requirements governing data management and security. It involves staying up to date with changing regulations, establishing data retention policies, and implementing data management practices that align with legal and regulatory obligations. Compliance with data protection laws and industry standards help organisations avoid legal and reputational risks. Data governance promotes the documentation of data-related policies, procedures, and data lineage. Have I said data 50 times yet? It enables a clear understanding of data sources, transformations, and usage within the organisation. By maintaining an audit trail and metadata, organisations can trace the origin, lineage, and transformations of data, ensuring transparency, accountability, and defensibility in legal proceedings. And finally, it assigns data stewardship roles and responsibilities to individuals within an organisation. Data stewards are accountable for ensuring data quality, integrity, and compliance with data governance policies. They act as custodians of the data, monitoring data usage, resolving data-related issues, and promoting a culture of responsible data management throughout the organisation. By implementing effective data governance practices, organisations can maintain the accuracy, reliability, and security of their data assets. Data governance frameworks provide a systematic approach to managing data, mitigating risks, ensuring compliance, and optimising the use of data for legal analysis. And now we have our data components in place. How does this help us when things go wrong? As of March this year, there were 2,784 recorded breaches since the start of 2020. And just last month, Russian hackers were able to access top secret defense data. The question has now moved from will we have a breach to what are we going to do when we have a breach and how can we minimize the impact? Ashes Advance helps organizations identify potential breaches and reporting requirements each day. However, having a comprehensive data management strategy in place will help reduce the potential impact of security incidences, assist with responding effectively to data breaches, and ensure compliance with legal and regulatory obligations. Here are some key considerations for incident response and data breach preparedness. Develop an incident response plan that outlines the steps to be taken in the event of a security incident or data breach. The plan should include clear roles and responsibilities, communication protocols, escalation procedures, and define incident response teams. Assign specific individuals to lead and coordinate the response efforts. Implement mechanisms to detect security incidents promptly. This can include intrusion detection systems, log monitoring, security event monitoring, and real-time threat intelligence. Establish clear procedures for reporting incidences internally and, if necessary, to external entities such as regulatory authorities and law enforcement agencies. Upon detection of a security incident, make immediate action to contain and mitigate the impact. Isolate affected systems, disconnect compromised accounts, and implement remediation measures to prevent further unauthorized access or data loss. Preserve evidence for potential legal or forensic investigations. Familiarise yourself with applicable data breach notification laws and regulations. Develop procedures to determine where and how to notify affected individuals, clients, and regulators and other relevant parties in the event of a data breach. Comply with the required notification timelines and provide accurate and timely information about the breach and the steps being taken to address it. Engage forensic and e-discovery experts when necessary to conduct thorough investigations into data breaches or security incidences. Forensic investigators can identify the root cause, assess the extent of the breach, and determine the impact on data integrity and help identify potential perpetrators, as well as preserve relevant logs, network traffic data, and other digital evidence. E-discovery experts can analyse the affected data and provide information on the scope and content. Has client information been compromised? Have other organisations' data been infected? Is the breach as disastrous as individuals' personal information being compromised, or has your Neopets account been leaked onto the dark web? Identifying the scope will inform the response severity. Understanding the legal and regulatory obligations associated with data breaches. Determine reporting requirements to regulatory bodies. For example, at this time, ASIC has updated their breach reporting requirements, now requiring requiring credit and AFS licensees to report breaches within 30 days of knowing. Complying with breach notification laws, data breach record keeping obligations, and other relevant legal requirements specific to your jurisdiction. After resolving a security incident or a data breach, conduct a post-incident review to identify lessons learned, areas for improvement, and potential security gaps. Update incidents reports, plans, security measures, and training programs based on these findings. Continuously monitor and improve incident response capabilities to enhance future preparedness. The greatest weak point will always be human fallibility. One of my favourite training stories is a law firm testing their data governance by placing 50 unlabelled USBs in an office to see how employees would react to an unknown device appearing without explanation. 49 of the USBs were plugged into network computers without a second thought, and the remaining USB was lost. Regularly train employees on incident response procedures, data breach prevention, and cybersecurity best practices. Increase awareness of common attack vectors, phishing scams, and social engineering techniques. Encourage employees to promptly report suspicious activities or potential security incidences. Conduct regular tabletop exercises or simulated incident response drills to test the effectiveness of the incident response plan. These exercises help identify gaps, improve coordination amongst response team members, and ensure that the plan is up to date. Periodically review and update the plan based on lessons learned from testing. By incorporating incident response and data breach preparedness into data management strategies, organisations can respond effectively to security incidences, mitigate the impact of data breaches. Now that we've identified the types of data we can collect and how to ensure its integrity when we collect it, what can we do with the data? Document review has come a long way from a large team of paralegals taking months to review case material. Developments in e-discovery have allowed us to harness deduplication, email threading, and concept analysis, but two of the most exciting tools we have in our kits are continuous active learning, or CAL, and sentiment analysis. But what is CAL? Continuous active learning comes in many forms depending on the application that you're using, and typically leverages advanced artificial intelligence such as machine learning to assist in case analysis and decision making. Here are some further insights into the benefits and application of CAL in the legal field. CAL can analyse vast amounts of data with ease by leveraging AI and machine learning algorithms. CAL can identify relevant concepts and privileged language based on reviewer input. This level of comprehensive data analysis enables us to uncover insights and make more informed decisions more efficiently. Continuous learning and improvement. CAL continuously learns and improves through feedback and user interactions. For example, as legal professionals review documents for relevance, they are providing CAL with input on the relevance of the unreviewed documents and quality of the results, enabling the system to refine its algorithm and recommendations. This iterative learning process ensures that CAL becomes more accurate and efficient as the review progresses. CAL significantly reduces the time and effort required for legal research. By automating the process of searching through extensive databases, CAL quickly retrieves relevant information. This efficiency allows legal professionals to focus more time on the critical analysis, strategy development, and client interactions, leading to increased productivity. We use CAL on most document reviews to predict when we have exhausted relevant material in a database using a scientific algorithm to score each document, sampling and illusion testing. CAL can be used to push documents that are more likely to be relevant to the top of the review pool to reduce unnecessary review of relevant material and to reduce reviewer fatigue. Like everyone who hears about CAL for the first time, you think, wow, this is amazing. We should use CAL to help us on all document reviews. But there are certain situations where CAL may not be suitable or effective. CAL may struggle to handle complex legal issues that require nuanced interpretation, deep legal expertise, and contextual understanding. These types of reviews may require human expertise and judgment that CAL does not possess. I can assure you that CAL is not taking over the legal professional jobs just yet. CAL relies on human review to train the CAL model to understand material and make accurate predictions. Without continuous feedback, CAL may not be able to grasp the specific nuances and context of documents being reviewed. Unstructured data. Remember when I said knowing the different types of data would be helpful to understand when you structure your review? Handwritten documents, scanned images, complex spreadsheets, images. CAL systems primarily excel in processing and analysing structured textual data and may not be as effective in handling unstructured or non-textual content. CAL continues to be one of the most used and powerful tools we have to reduce review time and costs, but it's essential to carefully assess the suitability of CAL for your dataset. So what's a real-life example of CAL working successfully? An Australian company was issued with a legal notice by the ACCC. Ashes Advance were appointed to provide our client with end-to-end document management solutions for their regulatory response spanning from collection to processing, document review, and production. We were granted access to their systems, enabling us to collect approximately 4 million potential relevant emails. Also collected 4,700 hours of audio, or 68,000 files, including phone calls from customers. These audio files were converted to text for review. Our initial deduplication and keyword searching reduced the document review from 4 million to 125,000. Through the application of CAL, we were able to further reduce the review population to 33,000 documents. This careful, thoughtful use of technology enabled an overall 99% reduction of the review population, resulting in significant cost savings. Our work on this project enabled our client to rapidly respond to the ACCC and achieve significant cost savings. Our use of CAL was particularly instrumental in delivering these outcomes, and our success was demonstrated by the client re-engaging us to provide the same services on a similar subsequent matter. Sentiment analysis refers to application of natural language processing techniques to analyse and extract the sentiment and emotional tone expressed within text. It aims to understand the subjective opinions, attitudes, and emotions conveyed in the language used. By analysing the sentiment analysis of email conversations within data, sentiment analysis can reveal the emotional tone or sentiment expressed in written communications. It can identify positive or negative sentiments, allow us to understand the overall sentiment and attitudes of custodians towards specific topics, events, or individuals. Sentiment analysis on custodian data can analyse internal communication channels such as chat logs, internal memos, or collaboration platforms. By examining the sentiment within these communications, we can gain insights into the attitudes, opinions, and potential conflicts among custodians within an organisation. Applying sentiment analysis to custodian data during document review can assist with identifying and categorising documents based on their sentiment. This can help prioritise relevant documents, flag documents with strong positive or negative sentiments, or identify potential areas of further interest for investigation. It's important to note that sentiment analysis of data is an augmentation tool that supports legal professionals in their analysis. It should not replace the expertise and judgment of legal professionals, but rather complement their work by providing additional insights into the emotional aspects of documents. We should critically evaluate the sentiment analysis results, consider the context, and exercise their professional judgment when interpreting the sentiment conveyed. While sentiment analysis can be a valuable tool in investigations, there are certain scenarios where they may not be suitable or may provide limited insights. Here are some situations where sentiment analysis may not be ideal. Sentiment analysis algorithms are trained on general language patterns and may struggle to accurately analyse documents with technical or highly specialised content. Data can contain legal language, technical terms, and industry-specific jargon that may not align well with the sentiment analysis models. In such cases, human expertise and domain knowledge are crucial for accurate interpretation and analysis. Sentiment analysis algorithms primarily focus on individual sentences or phrases and may struggle to grasp the full contextual meaning. Ambiguities in language, sarcasm, or irony can be challenging for sentiment analysis models to accurately interpret. The context of documents often plays into a significant role in understanding the intent and tone, and sentiment analysis may not be able to capture the complete picture. Data can involve complex emotions such as frustration, disappointment, or satisfaction, expressed in a formal or structured manner. Sentiment analysis models may struggle to capture the emotional complexity in these documents accurately. The formal and structured nature of legal language may not align well with the sentiment analysis models trained on more informal and conversational text. Similarly, documents translated to English may face challenges due to language nuances, idiomatic expression, and potential loss of meaning during the translation process. While considering the use of sentiment analysis document review, we should carefully evaluate the suitability of sentiment analysis for the specific document type and context. It's important to understand the limitations of sentiment analysis and supplement it with human expertise to ensure accurate interpretation, contextual understanding, and appropriate analysis of data. I promised you a story on recognising patterns, so here we go. An Australian company suspected one of their long-term employees was involved in some professional misconduct. The client engaged us to undertake an investigation of the employee's conduct, starting with a review of their work emails. So as to not influence our findings, they did not provide us with any information regarding the suspected misconduct. We ran sentiment analysis across the employee's email accounts using Reveal, an AI-powered investigation platform. Nearly every single email in the inbox was full of behaviour that you would expect to see at a football match and not in the work environment. The client was given examples of the findings and they had already been aware of this behaviour and were looking for evidence outside of this interesting way of communicating. By switching the algorithms to look at emails with low negativity, we were able to immediately identify a number of communications which were obvious outliers from the employee's usual communication style and which appeared to be consistent with serious misconduct by that employee. The relevant correspondence was provided directly to the client for further internal investigation without the need for us to undertake any manual review. We were able to find the relevant correspondence and provide a report to the client in less than 2 days, despite not having any information regarding the alleged misconduct. More traditional digital approaches would have taken us weeks to achieve the same outcome. So these are the technologies that we're currently using, but what does the future hold in this space? The future of AI and law encompasses a wide range of emerging trends, advancements and ethical considerations and implications for the legal profession and the justice system. So let's dive into the exciting future and look at emerging trends and advancements. AI-powered tools can enhance legal research by efficiently analysing vast amounts of legal data, identifying relevant precedents, and providing insights into case analysis. Platforms such as Moonlit are leading the way on international case law research, although you might want to manually verify the precedents if you're using ChatGPT. AI can streamline contract review processes by extracting key provisions, flagging potential risks, and automating contract creation and management. We've quickly advanced from basic contract entry and response-like programs to automated contract drafting, negotiation, and markup. Companies such as Luminance are now using advanced custom language models to pull from existing contracts to assist with contract drafting. AI algorithms can analyse historical data to predict case outcomes, litigation risks, and settlement probabilities, assisting legal professionals in making informed decisions. Many universities are creating databases of case law to assist AI in making these decisions. Natural language processing, or NLP advancements, enable AI systems to understand and process human language, facilitating more accurate document analysis, summarization, and information extraction. We spoke about this with sentiment analysis, but its powers are endless. Could you point it at a social media platform and provide insights on public perceptions and reactions? Could you point it to a witness statement and identify bias? AI-powered virtual assistants can provide legal information, answer common queries, and assist in client interactions, improving efficiency and accessibility. I can see this moving into the document review space to assist with platform usability, instead of contacting your helpful e-discovery team when you can't remember how to turn attachments on. While we all love shiny new tech that makes our lives easier, there are ethical considerations and challenges when using AI. AI systems require access to large amounts of data, raising concerns about privacy and the protection of confidential information. Organisations must ensure compliance with data protection laws and implement robust security measures and discourage employees from using ChatGPT-4 to complete their compliance training. AI algorithms may inadvertently perpetuate biases presented in the data that they're trained on. Efforts may be made to identify and mitigate bias, ensuring fair and equitable outcomes. If you asked AI to analyse this presentation, the AI might tell you that storing the data in the cloud is the best way to store data because that's my bias, but it might not be true in different scenarios. AI systems must be transparent and accountable. Understanding how AI arrives at a decision or recommendation and being able to explain the reasoning is crucial in the legal context. Question the products that you're seeing on the market. What are the mechanisms behind the programs that are making them work? Legal professionals must exercise judgment and oversee AI system outputs, ensuring they align with professional ethics and legal obligations. Now that we're all AI champions, what will this mean to us in the legal profession? As always, there are positives and negatives. AI technologies can automate repetitive tasks, freeing up time for legal professionals to focus on higher value work, such as strategic analysis and client counselling. AI-powered tools can improve access to justice by providing affordable legal services, enabling self-help resources, and assisting in navigating legal complexities. AI can augment legal professional skills, providing them with data-driven insights, reducing errors, and enhancing decision-making. Potentially less positive if you're not adapting to technology, job transformation. Some tasks traditionally performed by legal professionals can be automated by AI, leading to changes in job roles and the need for upskilling to adapt in the evolving legal landscape. And of course, ethical dilemmas. The use of AI in legal decision-making raises ethical dilemmas such as delegation of judgment to machines, responsibility for AI-generated errors, and the role of human oversight. As we've learned today, it's crucial for all legal professionals and organisations to embrace the power of data and AI in the legal practice. By doing so, we can harness the benefit of efficient research, accurate analysis, and data-driven decision-making, leading to improved outcomes for clients, adapt to the evolving legal landscape, and leverage AI technologies to enhance productivity, streamline processes, and deliver value-added services. Address ethical considerations and challenges around AI adoption by ensuring fairness, transparency, and accountability in AI systems. Embrace continuous learning and upskilling to navigate the evolving role of legal professionals in this AI-enabled world. Collaborate with technology experts and policymakers to shape AI regulations and standards that align with legal principles and ethical frameworks. In conclusion, by embracing the power of data and AI, we can unlock new opportunities, improve client services, and drive positive changes in the legal field. With a thoughtful and responsible approach to data governance, AI integration, and ethical considerations, we can harness the potential of these emerging technologies while maintaining security, transparency, and professionalism. I think Terry was going to help us with some questions.
Yeah, absolutely. Thank you very much, Crystal. Great presentation, really clear overview of data and where we're going. And it's a huge topic. And I think you've broken it down in a way that has kind of put it into bite-sized pieces that we can process. So thank you very much for that. Really appreciate it. Just a quick reminder, if you have a question, please feel free. This would be your opportunity to throw that into the Q&A at the end of your screen. And we have a few coming in now. So Crystal, I'm just going to do these kind of in the order in which they're coming in. So the first one is, have you come across any AI tools that might assist with objective coding? And the example that's given is a 1,000-page scanned PDF of mixed documents.
Yeah, so there's a lot of tools out there that are starting to look at scanned documents. We've been using a few recently. They're more built into the relativity AI. So they're looking at handwriting documents. They're looking at particular parts of a form and being able to transfer that information from each form into a database-like structure. I haven't seen one that's going to help with titles and dates. If you ever find one, please let me know. That'd be great. We're not quite there yet, I don't think, because you'd be needing to read the information and making those assessments based on the face of the document, I guess. We're always at that position where the AI might be smarter at making decisions, but we're better at looking at the whole concept of a document and making a decision.
Yeah, absolutely. I think you're going to love this next question too, by the way. How do you defensively predict when relevant material has been exhausted in a CAL review?
Well, isn't that contentious? It depends on the type of review, to be honest, and what platform you're using. We are a UX house, so there's several ways that we would test. We do a sample test at the start of a review, have a look at what is predicted in the lower and upper bounds of relevance. And when we start to see the relevant material dipping, we might do additional samples to see if we can find any more pockets of relevance that haven't been found yet. Then we might do some analysis on the remaining documents. So let's have a look at what the scoring is like on the remaining documents. Are there any more positive documents that are potentially positive and potentially relevant? Have we gone through our QC set of checking documents? Something that UX does is tells us if a document's been coded relevant, but it looks like other documents that are similar have been coded not relevant. It gives us that information. So we would check those documents as well and do a final illusion test. So that's taking a large sample of documents and checking the percentage of relevance in that. So if it was quite a large relevance, or you're finding a lot of relevant documents, you would know that your document review has not been finalised. So there's several things and different ways that we can test. I don't think that you should be relying on one way. I think that's dangerous. You should be using several ways to make sure that your document review is complete.
Yeah, fabulous. So we're going to go into GPT land for a second here. What impact do you think that GPT will have on e-discovery platforms? And the example that's given to illustrate the question is, do you expect that we'll be able to run searches by asking the platform questions rather than running a Boolean search?
I think the concern with GPT in general is privacy. So if you put data into that platform, it is somewhere. So if you're asking it to run a search and look at your database, your client's data is now somewhere in GPT. So we already have issues. Like I said, people won't even give us data to put into the cloud sometimes. So then you should be applying those same policies to your database as well, just because everyone's using GPT and it's great, and it gave me that great buzzword title that brought everybody in today. It has some very significant security issues. Yeah. So using the kind of AI that GPT has, potentially we could pick up that kind of conversational AI, put it into a platform that doesn't look at the contents of the data, but might help you. Like if anyone remembers Clippy that used to be in your Word documents, you could have something similar to that pop up and say, hey, it looks like you're trying to run a search on the documents that contain book. Would you like some assistance with that? And it could pull up a page and point. So I see that being more helpful, like a service-based instructional help. I don't see it being able to assist with the actual review, because that has a lot of security issues.
So the next question, thank you for that. This next question is kind of related to that. Relativity has recently mentioned that they're integrating GPT-4 technology into their platform. One of many platforms, one would hasten to add, where this is being considered or done. Do you think we'll get to a stage where we can instruct the platform to run a preliminary level review accurately? So I guess it's, looking at efficiencies that might be gained to some extent by using this technology as much as anything else. So over to you on that one.
Yeah, I think there's lots of potential there, especially things like the daily reporting and the analysis of documents, of being able to assess trends. I mean, the medical industry is making huge advancements on this, of being able to pull out parts of analysis where things have gone out of scope. So you're looking at 500 different types of blood pressure and one is higher, then it automatically flags that one's the issue. So I don't see why we couldn't implement that to us. Running the whole review might be a bit of a stretch, because it comes into that idea of what is ethical. Are we going to trust a whole document review, or can we trust a whole document review to a robot? Is it going to make decisions like, well, we have to have the documents reviewed by Friday, therefore I'm going to reduce the population because that's what you want? Something that is really interesting about AI is that the biggest problem we have is that it lies, just like the man who tried to get some precedences for his information, and that it gave them some false precedences. AI is inclined to help you, and if you want it to do something, it's going to say, yes, that's the right thing to do. It's not giving you fair and partial information. It's biased towards helping you. So we have to be really careful about implementing it in ways where it could say, okay, well, to help you, I'm going to do this, but it's not actually defensible.
Let me ask you a question. So I'm going to take it out of e-discovery land for the moment and put it more into kind of the general data governance management sphere and ask this question, because I think a lot of folks are starting to turn their mind to data now, which is a great thing in law firms and in-house and everywhere else. But I guess what they're often presented with is an overwhelming amount of data in all kinds of shapes and sizes. And it's almost like, where do you start? And then, of course, if you want to deploy anything like the GPT technology, you've really got to kind of look at the quality of the data that you've got. So for those folks that are sitting there and feeling a little overwhelmed with all of this, what's your advice to them in terms of starting to get ready in a way, or get themselves, I don't know, organised, for want of a better expression, for data world?
I think the most important question everyone should be asking themselves is, where is your data located and how is it stored? It is ridiculous, really, how much we put data out there. We're on TikTok, we're on Facebook, we're on whatever, putting thousands of bits of our information, personal information out there. Same with your company as well, but you're not really sure where it's stored. So to be able to start any of this, including if you wanted to bring GPT into your company and help it assist you, you would need to know, one, where your data is and how is it being accessed, and how AI could access it as well, and what the implications are of that. Even with things like cloud storage, as much as I love it, you've got to make sure that it's in the right jurisdiction, that it's being used correctly, that other people don't have access to it. It's the same with AI as well. You've got to make sure that what you're putting into it's not client material, it's safe to go into that kind of platform, and where it's going to end up in the end.
Fantastic, great advice, and some of much great advice throughout the session. Thank you very much indeed for that. Sadly, we have to draw to a close. So I know that folks, with sessions like this, things often bubble up later, and I know that they can find you on LinkedIn, if not other places, and that you're open to folks approaching you and asking those questions. So thank you in advance for that, really appreciate it. Thank you everyone for attending. Obviously you'll find stuff about the Centre on social media as well, in particular LinkedIn, where you can kind of connect with us, but in a bunch of different places as well. Again, Crystal, thank you very, very much. Just a pleasure to have you here and for the session today.
Thank you so much.
You're most welcome, and thank you everyone again for attending. We'll see you next time. Thanks. Bye.